Good morning or good afternoon, depending on your time zone. My name is Christopher Friedman. I'm a partner in Husch Blackwell's Financial Services and Capital Markets Group, and I'm located in our Nashville, Tennessee office. I'm a regulatory and compliance lawyer operating primarily in the fintech space, representing both consumer and commercial finance companies. In particular, I assist companies in the financial services ecosystem with issues related to consumer protection, BaaS and SaaS deals, vendor compliance and management, fair lending and fair servicing, licensing, and state and federal regulatory exams. I also maintain an active alternative commercial finance practice, assisting companies in the factoring, supply chain finance, asset-based finance, and revenue-based finance space, as well as traditional small to medium-sized business lenders on regulatory issues and general business matters. Husch Blackwell has a national consumer financial services regulatory practice that focuses on helping clients implement important rules, among other CFPB initiatives. Now, before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. In addition, a PDF presentation will be available in the program materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Towards the end of the program, please be sure to complete our short survey. We love to use your feedback, plan future programs that are applicable to your business needs. Thanks all. This is all for the housekeeping items, so let's get started with the program. Joining me today is my law partner, Mike G. Silver, in our Washington, D.C. office. Mike is a partner who joined Husch Blackwell's Consumer Financial Services team in February of 2024 after more than a decade at the CFPB. At the CFPB, he played a crucial and central role in writing some of the agency's most impactful rules and guidance. Mike advises the firm's consumer financial services and fintech clients on regulatory and compliance matters. His practice blends both mortgage and non-mortgage lending and draws upon his broad portfolio of CFPB work, including issues related to UDAP, mortgage origination, and consumer lending regulations involving innovation, technology, and digital marketing tools, small dollar lending, deposits, and debt collection. And not presenting today, but who did an excellent job preparing our deck, is one of our talented new associates, Jacob Seidler, who is also, fortunately, one of the few other Alabama fans here at the firm. So we'll put that as a mark in his favor. He practices banking and finance law out of our Madison, Wisconsin office. So without anything further, we're going to go ahead and get into the meat of our agenda today. So let me talk a little bit about what we're going to discuss with regard to Dodd-Frank 1033. We're first going to talk about a general overview of the rule, and in particular, who is covered, what is covered, data from implications for the financial institutions, and then legal challenges. Keep in mind, this is a rule that came out last week. So really our goal here is to do a quick hit on some of the basics of the rule, because I know that a lot of folks have not had an opportunity to go through the larger regulatory issuance. So we've done that for you. But then we do want to spend some time talking about the implications of the rule itself. So with that, I'm going to start just by talking about some general background about open banking and what is it? Because I know a lot of folks have heard of the term open banking bandied about. It's kind of a buzz term in the space, but what exactly is open banking? And the idea is actually quite simple. It's the idea that banks and financial services companies will share financial services data utilizing open APIs with consumer consent. It kind of goes back to this broader idea that consumers ought to have control over their data. It is their data, so it should be easy for them to shop around for services. It should also be easy for them to utilize that data and give that data to other financial services companies so that those companies can use that data to derive things like creditworthiness determinations and to be able to service products a little bit better, with the idea being that it makes a more competitive marketplace in general and will inure to the benefit of consumers. Now, the United States has been a little bit behind in certain respects with regard to open banking. Europe really has been on the forefront for the EU. The Payment Services Directive, or PSD2, has governed open banking. In the UK, you have an open banking standard that has governed open banking. So Europe has done maybe a little bit better of a job, at least in terms of centralizing open banking and ensuring that there are standards that govern the industry. In the United States, we're a little bit messier. Maybe that shouldn't be surprising to a lot of you. We do things a little bit differently here in the United States, what with our rugged individualism and all. But aspects of open banking here have really been more driven by consumer demand and industry innovation. There really hasn't been a standard. So as of today, consumer access has been guided, to the extent there has been centralization, it's been guided by existing data laws, such as the Gramm-Leach-Bliley Act, or GLBA. There's been really an emphasis on things like data security, but innovation, but not really innovation and the development of data transmission. There really hasn't been a standard with regards to data transmission. And I think because of that, really the primary method that is developed, and one that's frankly attracted a lot of criticism based on security concerns, is this thing called screen scraping, right? We've all heard, or many of us have heard about screen scraping, and that is this method of obtaining consumer data where the consumer provides login information to a third party, like a consumer's login information, and then the third party obtains the consumer data from the consumer interface. Now, you can imagine why that has derived a lot of criticism in the market, right? You're giving out your login and password to a third party. There have been some innovations in that space that have made that means of obtaining data a little more secure, like using tokenized login information. But if you've spent time reading through the comments to 1033 or the preamble, you know that this screen scraping method has been highly criticized, and that's one of the goals of the CFPB, is to move away from screen scraping and create a true API system in which to derive consumer data. So that's kind of some of the background. Now, the rule itself has been, it's taken a while, which you've really seen that with Dodd-Frank. There are lots of rules in Dodd-Frank that haven't really gone into effect. Another great example of that is 1071. So 1033 has taken a while for this to take. And I think in part because the FPA has been more focused on things like mortgage and other aspects of consumer protection that were more pressing after the financial crisis. But Dodd-Frank 1033, from a statutory perspective, mandates that consumers should have access to their financial data and securely share this data with third parties. President Biden issued an executive order indicating that it was the administration's desire to begin the rulemaking process for Dodd-Frank 1033. It's again a little bit different than 1071, which is the small business lending data reporting requirements, which that ended up being a problem, getting kicked off because of litigation. That didn't really happen here. We had an instance where the administration actually started pushing for compliance or moving forward. In June, the CFPB finalized a separate rule addressing the data standard component of 1033. In October of 2024, the CFPB issued a final.
Hey, Chris. Sorry to interrupt. It seems like there's some issues with the
yes.
audio.
Okay, wonderful. That's not great. Can you hear me now? Is it working any better?
Yeah, it's kind of going in and out.
Well, Mike, this is okay. Well, Mike, this is your turn to jump in anyway. So we'll let you go ahead and take it from here, and I'll work on my computer.
Yes. No. So sorry about that, Chris. But yeah, I guess it's a good segue to where we are in the presentation. So just to ground the rule in the statutory provision. So this is section 1033A of the Dodd-Frank Act. And as you all know, the Dodd-Frank Act was passed in 2010. It was a reaction to a broad, comprehensive congressional reaction to the 2008 financial crisis. And as Chris was alluding to a minute ago, it might have not come through in some of the choppiness, but there have been a number of a number of statutory provisions that, for whatever reason, have taken a pretty long time to ultimately cycle through a rulemaking process. And so Section 1071, the Small Business Data Collection Rule, was one example of that. And this is another example. So as Chris was alluding to on the last slide, it's been about 8 years, starting with a request for information, moving to an ANPR, Advance Notice of Proposed Rule, a small business process. And ultimately, the proposal was last year, and now we have the final rule. But this all goes back to the statutory provision. It is 2 sentences, at least in Section A. And just to basically paraphrase it, subject to rules prescribed by the Bureau, a covered person shall make available to a consumer upon request information in the control or possession of the covered person concerning the consumer financial product or service that the consumer obtained from such covered person, including information relating to any transaction, series of transactions, or to the account, including costs, charges, or usage data. The information shall be made available in an electronic form usable by consumers. Section 1033B provides certain exceptions from coverage, and Chris will cover this later in the presentation. Those exceptions in the final rule were largely taken directly from the exceptions that are in the statute. So moving on to the next slide. And I'm assuming everybody's hearing me okay. I don't see anything in the chat to indicate otherwise, but please ping us through the chat if there's any issues on my end or going forward on Chris's end. So the rule has 2 major components. So one is to require financial service providers to make consumers' data available upon request to consumers and authorized third parties, so permissioned third parties. We're seeing some thumbs up, so that's good in terms of the audio. And then the second major component is defining obligations for financial service providers in providing and for third parties in accessing consumers' data. So just briefly on the timing related to the rule. And this was something that did change from the proposed rule to the final rule. The effective date is 60 days after the date of publication in the Federal Register. I don't believe the rule has been published yet. It likely will be published in the next week or 2. So then the clock will start. And then the compliance dates are staggered based on the size and the entity type. And we'll show this, illustrate this in a chart on the next slide. But basically, April 1st, 2026 is the first of those staggered dates, and it goes all the way through April 1st, 2030. And basically what this means, it's a phased compliance framework where the large institutions, depositories and non-depositories, are the first ones required to comply, and then moving down the stack to smaller and smaller institutions. And then as we'll talk about, there also is an exemption for very small institutions under $850 million in assets. So here's the chart illustrating the fine details of the stage compliance. And again, as indicated, the largest institutions, depositories and non-depositories, have to comply on April 1st, 2026. And this was an important and I think welcome change from the proposal. The proposal, if I recall correctly, would have required 6 months of compliance, which really wasn't a reasonable period. So the CFPB did adhere to commenters' suggestions to lengthen the period. Now, one just fine point to note here in terms of the size thresholds, the second row in the chart talks about non-depository institutions that generate at least $10 billion in total receipts in either 2023 or 2024. And also the fourth row shows, the similar provision for non-depositories that are below $10 billion. There was some question in the proposal as to whether that threshold for calculating the size of the non-depository institution had to take into account the revenues of affiliates or subsidiaries. And in the final rule, the CFPB did clarify that $10 billion threshold for purposes of calculating the receipts, which in turn will determine when the compliance date takes effect for that entity, it does include revenues of affiliates or total receipts of affiliates. And they talked about how they're relying on certain standards from the Small Business Administration, and there's a statutory cross-reference and the like. So we just wanted to point that out. Now I'll turn it back to you, Chris.
All right. Now let me just start by asking, can everyone hear me now?
I can hear you.
That's fantastic. So what we're going to do now is really talk about the structure of 1033, right? And when I think of 1033 at a very high level, there are really three primary players of the 1033 game, with one kind of sub player that's connected to one of the players. The first one being data providers. And your data providers are the entities who actually hold the data, right? So think depository institutions, lenders, credit card providers. That's a data provider because that is the entity that is going to provide the data. In our current system, it's the entity whose screen would be scraped if you were utilizing the screen scraping method of obtaining data. Your second entity is consumers, right? The entities whose data, at least under the philosophy of 1033 and open banking, consumers are the entities who actually own the data and should have the ability to port their data from institution to institution. And then the third player is what's called an authorized third party. And those could be other banks or depository institutions. Those could be other lenders who might want to have that consumer's data ported over to them so that they can provide services to the consumer, or so they can underwrite the consumer for a loan. Those third parties will have the ability to go on their own and obtain the data from the data provider under certain circumstances. Those third parties can also utilize the kind of sub-party that I talked about, and that is a data aggregator, right? Let's say you are an entity and you might have need for the data, but you might not have the resources to come up with a system by which you can obtain that data. For whatever reason, you might work with a data aggregator to help you go about getting the consumer data so that you can maybe underwrite a loan or do something else. So those are the three main players in this area, and that's kind of how we're going to structure this discussion of what this rule actually means. So starting with data providers, well, who are data providers? And under the rule, a data provider is a financial institution that is as defined in Regulation E. So that means a bank, a savings association, a credit union, or any other person that directly or indirectly holds an account belonging to a consumer, or that issues an access device, like a credit card, and agrees with a consumer to provide electronic funds transfer services. So that's one way you could be a data provider. Or a card issuer, and that's as defined in Regulation Z. And that just means a person that issues a credit card, or that person's agent with respect to a card. Now, one really interesting thing with regard to the rule, and a kind of a change from the proposed rule, was that the CFPB was very clear in the final rule that digital wallets were going to be provided and included as data providers, right? So entities who facilitate the transfer of payment either via a credit card or a Regulation E account. It expressly states that digital wallets are considered data providers, even when they are only facilitating pass-through payments. So the result is that many of the most popular fintech payment platforms and wallet providers, like Apple Pay, is my primary example because it's what I use on my phone, will be subject to the open banking regime. Another interesting thing that we saw in the final rule that we really didn't see in the proposed rule is that buy now, pay later companies are also included. And that's expressed in the preamble to the rule. So those are your entities who are included as data providers. Now, we also see some exempt entities, and there was a change here from the proposal. So data providers are exempt if they are a depository institution or credit union with less than $850 million in assets. Now, this number is going to fluctuate based on the SBA size standards as referenced in the final rule. But one interesting thing I noticed in some of the comments and some comments I've seen lately is that a lot of smaller institutions have said, hey, this could actually put us at a competitive disadvantage, right? Because, one of the things that has driven this rule forward and driven the idea of open banking is that consumers want the ability to port their data. And if you have small, to comply with this, those community banks and community credit unions might have a shrinking kind of population of potential customers, because there are a lot of customers out there who expect the portability of their data and information. So one interesting thing I'm kind of looking forward to seeing a dynamic here is how are smaller banks and credit unions going to really work through this, because they might actually want to be able to offer these solutions to their customers, and I think we can all agree that complying with 1033 and creating the actual APIs is going to be expensive, and I think it might be a difficult proposition for some smaller players in the space. So very interested in seeing how that all shakes out. So that is who is covered. Now I'm going to pass it over to Mike to discuss what information must actually be provided under the rule. Mike, you're muted.
There's already a number of questions in the chat. Some of them relate to what types of financial institutions are covered. A pension plan, for example, debit cards. There was one question about commercial lenders. So we, as Chris said at the beginning, we'll do our best to kind of multitask and try to answer these questions in real time. But it may be that in some cases we'll follow up with you separately. Yeah. So maybe Chris can.
And I do want to follow up on one question that was just asked. Can smaller banks opt in? It's my reading that smaller banks can in fact opt in. There's nothing preventing a smaller bank from opting in. At least there's nothing in the rule that I've read that would prevent that. I think the problem for smaller banks is going to be just generally the expense of coming into compliance with the rule, and I think it's going to be it's going to take some time and effort to create these APIs, and we're going to get into this in a little bit, but we don't actually know the specific rules with regard to how the APIs are supposed to be structured, because that the process of creating those detailed rules is going to come through a self-regulating or self-governing organization. We'll get into that, but I do think the problem is not necessarily that they can't. It's going to be the expense of actually doing so.
Yeah, thanks, Chris. There also was a question, you may touch on this later, about coverage for commercial lenders.
Yep.
And then debit cards was also another one. So for now, I will let me talk about what is the covered data. If you recall, towards the beginning of the presentation, I was reading from the statute, and certain types of covered data were mentioned in the statute specifically. It said costs, charges, and usage data. Well, those are somewhat nebulous terms. So obviously the CFPB, in writing the rule, had to put some meat on the bones. Now, of course, one of the major issues that was discussed in comment letters, and also is now coming up in the legal challenge filed by a trade group and a bank in Kentucky, we'll talk about that later, is the breadth of covered data and the specificity of some of that covered data, and the arguments that it goes beyond those statutory covered data elements that were specified. But in any event, summarizing, the 6 categories of covered data are transaction information, and that goes back 24 months, account balance information, information to initiate payment to or from a Regulation E account. So payment initiation information is, I guess, the shorter way to phrase that. And that includes account and routing numbers. And I think Chris also might have touched on the idea of a tokenized account number, or a TAN. And that was an issue that also came up in some spirited debate in the comments. The 4th category is terms and conditions of the agreements between the data provider, institution, and the consumer, upcoming bill information, and basic account verification information. So in terms of what information is excluded, and again, some of this comes directly from the statute, although the CFPB did go in a slightly different direction in some respects. And Chris also will probably elaborate a bit on the first one, which is confidential commercial information. The second one, information collected for the sole purpose, I emphasize sole, of preventing fraud, money laundering, or other unlawful conduct. Third is information required to be kept confidential by another law. And fourth is any information not retrievable in the ordinary course of business. Now, I guess, Chris, I'll kick it back to you to talk a little bit about the first one.
Yeah, well, and it's not, so this is really, there's kind of 2 issues here. First of all, in terms of confidential commercial information, that's information like trade secrets and in anything that a data provider would be able to say, look, that's proprietary. I think I did want to spend some time answering a question about commercial finance products and whether or not commercial finance products are covered by the rule. And I think it's a fairly, it's not a simple question, but I think one thing that in reading the rule I appreciated seeing from the CFPB was that, unlike maybe some other rules, it was very clear that this rule in particular relates to consumer financial products and services. And it defined financial products or services is defined as products or services offered for use by consumers, and consumers defined as a natural person, guardian, trustee, custodian, or other similar natural person acting on behalf of a consumer pursuant to state law. And that the financial services are offered, and this is always the key word when you're thinking about the difference between consumer and commercial, or the key phrase, offered primarily for personal, family, or household purposes. So you're looking at Reg E accounts, which are consumer accounts, and then services that facilitate payments from Reg E accounts. But then also you're dealing with Reg Z credit cards. And those Reg Z credit cards can, that doesn't necessarily exclude business purpose credit cards, but when you look at all of the definitions